I threw open that door, stepped into my own house, and said 4 words. My son-in-law went pale as a January sky. His mother grabbed her handbag and bolted for the back hallway. Before I tell you how that night ended, let me take you back to where it started. Before continuing, please subscribe to the channel and drop a comment telling me what time it is where you are right now. My phone buzzed on the nightstand at 9:47 on Boxing Day evening. I was sitting in my hotel room in Toronto, still in my dress shirt from the day's conference, reviewing files I'd brought along out of habit. 40 years as a forensic accountant will do that to a man. Retirement is a word, not a practice. The text came from a number I didn't immediately recognize, Margaret from across the street. She identified herself in the second message, then sent a video file without any further explanation. I'd met Margaret twice. Once at my daughter's housewarming, 4 years ago, when I'd flown in from Ottawa to help move furniture and pretend I wasn't worried about the mortgage I'd co-signed. Once again last summer when I'd come to repaint the back porch. She was a retired school teacher, quiet and observant, the kind of neighbor who notices things without meaning to pry. She'd waved from her driveway. We'd talked about the weather for approximately 90 seconds. There was no reason for her to be texting me at 9:47 on Boxing Day unless something was wrong. I opened the video. The footage was shaky at first, shot through a window from across the street, the winter darkness making the image grainy and raw. But the kitchen light inside the house was on, the way it always is during dinner, and everything was visible enough. My daughter was standing near the counter in a red sweater. She was holding a casserole dish with both hands. My son-in-law was across from her, and I could see from the angle of his shoulders, from the way his whole body leaned forward, that he was shouting. A moment later, he swept his arm across the counter and sent a wine glass shattering against the floor. My daughter flinched back against the wall. He moved toward her. His mother appeared from somewhere off frame and stood watching with her arms crossed. Then my son-in-law grabbed my daughter by the wrist, pulled her toward him, and struck her hard enough across the face that she stumbled sideways into the cabinet. His mother didn't move. She picked up what remained of her own wine glass, took a calm sip, and sat back down at the table. In the background, pressed flat against the refrigerator with both hands over her mouth, was my 6-year-old granddaughter. I watched the video 3 times. The first time I felt sick. The second time I felt something go very cold and very quiet inside my chest. The third time I watched it the way I used to watch financial records during an audit, methodically, noting details. My son-in-law was unsteady on his feet. The bottle of Pinot Noir on the counter behind him was nearly empty. The clock on the microwave read 7:23 p.m. My daughter's granddaughter was wearing her Christmas pajamas. I called Margaret. She answered immediately. "How long ago did this happen?" I asked. "About 2 hours," she said. "I filmed it through my front window when I heard shouting. I thought about calling the police, but I didn't know if I should. I found your number in the card you left on the door 4 years ago when you were painting the porch. I kept it. I don't know why." "You did exactly the right thing," I said. "Can you send me the original file by email?" "Already typing it," she said. "Are you coming?" "I'm in Toronto. That's 2.5 hours. 2 hours if I leave now," I said. "I'll call the police from the road." I was in the elevator before she replied. The drive east on the 401 gave me time to remember things I'd been pushing to the edges for the past 1.5 years. My daughter calling less. The way she'd started hedging everything she said, softening it, apologizing before she'd even finished a sentence. Thanksgiving in October, when she'd worn a long-sleeved blouse, despite the heating being on, and when she'd reached across the table, I'd seen a bruise the color of old plum along her forearm. She'd said she'd caught it on the car door. I hadn't pushed. I hadn't wanted to be wrong. I'd been wrong to stay silent. That ended tonight. I thought about the house. 4-bedroom colonial in Kingston's West End, purchased in my name in the spring 4 years ago. Market value at the time was $680,000. I'd put in $340,000 cash as the down payment, and co-signed a mortgage for the rest. The title was in my name alone. My son-in-law had asked me twice in the past 2 years to transfer the deed to a joint name. Both times my daughter had quietly changed the subject, and I'd taken my cue from her and let it go. At the time, I thought she was being considerate of me. Now I understood she'd been protecting something she knew better than to let go of. And I thought about the cameras. 4 months ago, in August, I'd flown to Kingston for what I told everyone was a long weekend visit. I'd brought a tool bag and a Costco box of smart home devices and spent 2 days installing them throughout the house while my son-in-law was at work and my daughter took my granddaughter to the splash pad. My son-in-law noticed them when he got home and asked what they were. Home security system, I said. Motion activated. Links to my phone so I can keep an eye on the place when nobody's home. He'd looked at them for a long moment, then shrugged and gone to pour himself a drink. They weren't just motion sensors. They were 4K cameras feeding live to a cloud server registered in my name, accessible only through my credentials. I'd been watching for 4 months. Not every hour, not obsessively, but enough. Enough to build a picture I hadn't wanted to see. I crossed into the Kingston city limits at 11 minutes past midnight. The streets were empty, Boxing Day long since folded into a quiet night. I drove past the Tim Hortons on Princess Street, where I used to take my granddaughter for hot chocolate. Past the park, where she'd learned to ride a bike in September. Past every ordinary corner of the life my daughter was living inside that house. I pulled up across the street at 12:19 a.m. The lights inside were still on. Through the front window I could see my son-in-law on the couch. His mother was in the armchair beside him. They looked relaxed. They looked like people who had finished an unpleasant task and moved on. I called the Kingston Police non-emergency line. I have video evidence of a domestic assault that occurred this evening at approximately 7:23 p.m. I'm outside the property now. I have the victim's father outside, I said. I gave them the address. The officer told me units were on the way and asked me to wait. I'm not waiting in the car, I said, and ended the call. I got out, crossed the street, walked up the front path of my house, and opened the door. I hadn't needed to kick it. I had a key. I'd always had a key. It was, after all, my house. My son-in-law lurched to his feet when he heard me come in. His mother stood more slowly, the particular dignity of a woman who thinks she controls every room she enters. My son-in-law started with the obvious. What the hell do you think you're doing? It wasn't even really a question. It was bluster from a man trying to locate his confidence. I said 4 words. Sit down. Stay quiet. Not loud. I've never needed volume. 40 years of sitting across tables from people who'd stolen millions from their companies, from their partners, from their employees, taught me that volume is what people use when they don't have the facts. I had the facts. My son-in-law's mouth opened, closed. He was a real estate agent, 36 years old, and he'd built his entire adult life on the ability to talk people into things. He looked at me now like he was searching for the angle and couldn't find one. His mother recovered first. She had that particular composure of someone who'd learned to perform innocence as a full-time occupation. Robert, she said, using my name the way people use a tool. You can't just walk into someone's home. I walked to the center of the room. I looked around. The wine bottle on the coffee table. The broken glass someone had swept into a pile near the kitchen doorway. The chair overturned near the back wall. The evidence of a Boxing Day that had gone the way Boxing Days apparently went in this house. This is my home, I said. My name on the mortgage. My money in the walls, the floors. The roof I replaced 18 months ago. The furnace I paid $9,200 for last winter. My house, which you've been occupying while you terrorized my daughter. My daughter appeared in the hallway doorway. She'd changed out of the red sweater. She was wearing a gray hoodie now, sleeves pulled down. But when she looked up at me, the bruise was already forming on the left side of her face, swollen and darkening. Her eyes when she saw me were the eyes of someone who'd stopped expecting rescue. Come here, I said. She crossed the room, and I put one hand on her shoulder, lightly, careful of what might hurt. Pack a bag for you and your daughter. Enough for a few nights. We'll come back for the rest. My son-in-law found his voice. She's not going anywhere with you. We had an argument. Couples have arguments. You're not part of this. I turned to face him. I called the police before I came inside, I said. They'll be here in a few minutes. I have video footage of what happened tonight at 7 23 p.m. I also have 4 months of interior security camera footage recorded from the devices I installed in August. Everything is time-stamped. Everything is backed up to a cloud server. Everything is going to be presented to the Crown. The shift in his face was remarkable. The bluster didn't leave all at once. It drained, slowly, like pressure releasing from a valve. He looked at the camera in the upper corner of the living room, then at the one above the kitchen doorway, then back at me. "Those are supposed to be motion sensors," he said. "They sense motion and record it in 4K, I said. "For 4 months. His mother made a sound I can only describe as a hiss. She grabbed her coat from the hook by the door. "Derek, we need to leave." I smiled. It was not a warm expression. "The police will be very interested in why you're leaving the scene." She stopped. She looked at me with the first honest thing I'd seen from her in 4 years. Pure hatred, which I found far more tolerable than her fake warmth. The sirens arrived outside. Red and blue light through the front windows. 2 officers came through the door with exactly the kind of efficient calm that gets the job done without drama. They assessed the room, assessed my daughter's face, assessed me. I identified myself, told them I'd made the call, handed my phone to the lead officer, a woman named Constable Rayom, with Margaret's video already cued. She watched it once, her jaw set. She didn't say anything, but she nodded. "I also have interior camera footage," I said. 4 months of it. "I can give you access tonight." Constable Rayom gave me a look that was professional but clear. "You prepared for this." "I suspected," I said. "I documented. 40 years as a forensic accountant. I document things." My daughter gave her statement in the kitchen while I sat with my granddaughter in her bedroom. The little girl was awake, sitting up in her bed with the nightlight on, her stuffed rabbit pressed against her chest. She was 6 years old and she had her mother's eyes. She looked at me and said, "Grandpa, is Mommy okay?" "Mommy is okay," I said. "I'm taking you both to stay with me for a little while. How does that sound?" She considered this with the gravity that 6-year-olds bring to serious things. "Can I bring my rabbit?" "Absolutely," I said. When I came back out into the main room, Constable Rayom's partner was putting handcuffs on my son-in-law. He was saying something about misunderstanding, about context, about stress. His mother was on her phone, very quietly, with her back to the room. "Ma'am," Rayom said, "you'll need to come with us as well." His mother put the phone down slowly. She looked at my daughter in the kitchen doorway, and then she looked at me. "You've destroyed this family," she said. "You helped," I said. They walked both of them out to the patrol car. My son-in-law's shoulders were hunched, the particular posture of a man who has just discovered that the world does not find him nearly as charming as he finds himself. His mother sat in the second car with the expression of someone composing a narrative she planned to believe. I drove my daughter and my granddaughter back to the Holiday Inn where I'd kept my room. My granddaughter fell asleep on the back seat before we reached Princess Street. My daughter sat in the passenger seat with her hands folded in her lap and didn't speak for a long time. "Dad," she finally said. "How long have you known?" "Suspected," I said. "Since Thanksgiving. Known for certain. Since tonight. I should have told you. You weren't ready. And you were scared. That's not your failure. That's what people like him count on." She pressed her forehead against the cold window and watched the sleeping city go by. "He told me you wouldn't care. That you were too caught up in your retirement projects. That you'd always thought he wasn't good enough and you'd use any excuse to interfere. I drove and let that sit for a moment. He was managing your expectations of me," I said. "Making sure that when things got bad enough that you might reach out, you'd already talked yourself out of it. It's a very specific kind of control. I've seen it in financial fraud cases. Isolate the target from their support network, then make them feel responsible for their own isolation. He's better at it than I'd like to admit." She was quiet for another minute. Then she said, "He's going to fight this. I know. Let him." She looked at me. "You sound very calm." "I have a plan," I said. I spent the next morning on the phone while my daughter slept, and my granddaughter watched cartoons on the hotel television. First call went to Patricia Osei Bonsu, a criminal lawyer in Kingston who specialized in domestic violence, prosecutions, and who I'd been referred to 3 months ago by a colleague in Ottawa, just in case. She answered on the second ring, even though it was still early. "I heard your message from last night," she said. "Send me everything you have. All of it." Second call to Martin Chow, my property lawyer in Ottawa. "Martin," I said, "I need to initiate eviction proceedings on a property in Kingston. Unlawful occupants. Domestic violence context. How fast can we move?" "In Ontario," he said, "unlawful occupants without a formal tenancy agreement are not protected under the Residential Tenancies Act. With a criminal record and an active restraining order, we can move immediately. Emergency basis. You could have possession within 2 weeks. Do it." Third call to my accountant. I needed a full financial accounting of every dollar I'd put into that house. Down payment, mortgage payments, every repair, every upgrade, every property tax bill for 4 years. He called me back 2 hours later with a number. $417,000. That was what the house had cost me since the day I'd signed the papers. My son-in-law had paid approximately $11,000 toward the mortgage over 4 years, in irregular payments, always after I'd asked directly. Patricia called me back that afternoon. "Robert," she said, "I've watched everything, the neighbor's footage, and the full 4 months of interior recordings." She paused. "This is one of the most complete evidence packages I've seen in a domestic violence case in 20 years of practice. Do you know how unusual this is?" "I know how to document things," I said. "The Crown prosecutor is going to be very happy with you." She was quiet for a moment. "I'm filing for an emergency protection order today. Given the evidence, a justice of the peace will sign off tonight. Your son-in-law and his mother will be prohibited from coming within 200 meters of your daughter, your granddaughter, and the property. His mother." She threw wine in my daughter's face during the September 3rd incident, I said. "It's at timestamp 4 hours, 11 minutes in the archive. I bookmarked it." Patricia made a sound that was half laugh, half exhale. "Right. I'll include her." The protection order came through the next evening. Patricia called to confirm it, with a satisfaction in her voice that I understood because I felt it myself. My son-in-law appeared at his bail hearing 48 hours after Boxing Day, wearing a sport coat that didn't fit anymore. The borrowed clothes of a man whose confidence has left without forwarding its address. The Crown opposed bail on the basis of the video evidence and the documented pattern of escalation. The Justice of the Peace set conditions. No contact with my daughter or granddaughter. No attendance at the property. Curfew. Regular check-ins. His real estate broker, who was present in the gallery, left before the hearing concluded. I would learn later that the brokerage had suspended his license pending the criminal proceedings. In Ontario, a real estate agent facing assault charges is not a real estate agent who inspires confidence in clients. His mother was released the same day with similar conditions. She went to stay with a friend in Belleville. She sent my daughter a text message that evening, reading simply, "You've ruined everything." My daughter screenshotted it, sent it to Patricia, and blocked the number. Martin Chow filed the eviction application on December 30th. The hearing was set for the 3rd week of January at the Ontario Superior Court of Justice. I drove down from Ottawa the night before and stayed again at the same Holiday Inn. My son-in-law arrived with a lawyer I didn't recognize, a young man who carried himself with the particular determination of someone trying to compensate for thin arguments with strong posture. His mother was absent. Separate proceedings. The judge, a woman with reading glasses pushed up on her forehead, and the manner of someone who had heard everything and was impossible to impress, opened by reviewing the property documentation Martin had filed. The property at 14 Lakewood Crescent, Kingston, Ontario, was purchased in the applicant's name on the 8th of April 2021 for $680,000, she said. Down payment of $340,000 paid by the applicant. Mortgage registered solely in the applicant's name. No lease agreement, no rental contract, no documentation transferring any ownership interest to the respondent. Is that accurate, Mr. Mackenzie? That's correct, Your Honor. She turned to my son-in-law's lawyer. You're claiming your client has tenants' rights under the Residential Tenancies Act? The lawyer straightened. Your Honor, My client has resided in the property for 4 years. He has made financial contributions to the property and has a reasonable expectation. He is not a tenant, the judge said. There is no lease. There is no rental agreement. There is no documentation of any kind establishing a tenancy relationship. Under Ontario law, a person who occupies a property with the owner's permission but without a formal tenancy agreement is a licensee. That license can be revoked. In this case, it has been revoked, and the respondent is also subject to a court-ordered protection order prohibiting him from attending the property. Do you have anything that addresses those two facts? The lawyer shuffled his papers. My client made improvements to the property. Kitchen renovation. New appliances. We have receipts totaling approximately. I stood. Your Honor, may I respond? The judge nodded. I walked to the clerk and handed over the folder Martin had prepared. Your Honor, I've provided a complete financial record of the property. Down payment, $340,000. Mortgage payments to date, $58,000. Paid by me. New roof in 2022, $14,800. Furnace replacement in 2023, $9,200. Electrical panel upgrade, $6,400. Property taxes and insurance, 4 years, $38,600. Total investment by the applicant, $467,000. I looked at my son-in-law. He was staring at the table. My son-in-law contributed approximately $11,000 to the mortgage over 4 years. His renovations, which I did not authorize and was not informed of, total approximately $18,000 by his own accounting. If we are measuring equity by financial contribution, I believe the arithmetic is self-evident. If he wishes to recover his renovation costs, he may submit a civil claim. I look forward to presenting the full documentation of my investment in that proceeding. The judge looked at the folder. Then she looked at my son-in-law's lawyer with an expression that communicated, clearly and without words, that she would like him to stop wasting her morning. Motion for emergency possession granted, she said. The respondent has 30 days to vacate the property and remove personal effects. The applicant's property remains in place. Any interference with or damage to the property will result in immediate contempt proceedings. She closed the file. We're done. My son-in-law sat for a long moment after she left the bench. His lawyer was already packing his briefcase. I walked past the defense table on my way out, and my son-in-law looked up. His eyes were red at the edges. He looked like a man staring at the ruins of something he'd never actually built. You took everything, he said. My career, my house, my family. I stopped. I looked at him. I want you to listen carefully, I said, because this is the last time I'll speak to you directly. You took those things from yourself. The moment you first raised your hand to my daughter, you started the clock. Everything that followed was consequence, not punishment. You chose violence, and you chose it repeatedly, in my house. With my granddaughter watching, I didn't take anything. I just documented what you threw away. He opened his mouth. I walked out. In the corridor, Martin shook my hand. That folder presentation, he said. 30 years of property law. I've never seen a more methodical dismantling. I didn't feel like celebrating. I felt like a man who'd had to do something necessary and would have given a great deal not to have needed to. Patricia called me that evening with a further development. The Crown's investigation of the financial records my camera footage had captured had been referred to the Financial Transactions and Reports Analysis Center of Canada. My son-in-law had been claiming commission income from property sales through a numbered company in a manner that FinTrack considered worthy of investigation. Unreported income, potentially significant. The real estate licensing body had already been notified. How does a man who sells houses end up with financial irregularities? I said. The same way any fraud begins, Patricia said. He thought he was too clever to get caught. His broker's office terminated him permanently the following week. Without a license, he could not work in his field. Without income, he could not make bail conditions. Without income, or a home, or a professional future, the particular edifice he'd constructed on my generosity and my daughter's silence was reduced to rubble in 23 days. The criminal trial was scheduled for March. A Tuesday. My daughter testified. She was precise and calm and devastating. She spoke without drama, without embellishment, in the clear, straightforward manner of someone who has finally decided that the truth is not something to be ashamed of. Patricia had prepared her well, but the preparation had only directed what was already there. The jury watched the footage. 4 months of footage, edited to the most significant incidents and played on the courtroom screens. My son-in-law sat at the defense table and stared at his hands. He did not look at the screens. 17 minutes of evidence. The jury deliberated for 5 hours. Guilty. Assault causing bodily harm. Criminal harassment. Unlawful confinement on 2 separate occasions. His mother pleaded guilty to assault in a separate proceeding 10 days later. She received a conditional discharge, community service, and a prohibition order. She moved to Alberta in April. My daughter has not heard from her since. My son-in-law received 18 months of probation, mandatory domestic violence counseling, and a prohibition order extended to 3 years. No custody, supervised access only through the Children's Aid Society, 2 Saturdays a month. He attended 3 times before stopping. His lawyer's office sent a letter in June requesting a reduction in child support based on reduced income. Patricia's response was 4 pages long and left no room for further correspondence on the subject. The divorce was finalized in the summer. My daughter received full legal and physical custody of my granddaughter. The house was formally transferred into my daughter's name alone, registered as a gift, no encumbrances, no conditions. She cried when Martin sent her the transfer confirmation. I told her she didn't have to thank me. She said she wasn't crying out of gratitude. She was crying because she realized she was safe and hadn't felt safe in so long she'd forgotten what it felt like. I visited in July. Kingston in July is another thing entirely from Kingston in December. The lake visible from the end of the street, the maples full and dark green, the kind of afternoon that makes you understand why people choose to stay in a place through the winters. The house looked different. She'd repainted the living room a shade of blue I would not have chosen, and which looked exactly right. She'd taken down the heavy drapes my son-in-law had insisted on, and let the light in. My granddaughter had painted her bedroom door with handprints in 6 colors, and my daughter had let her. We sat on the back porch after dinner. My granddaughter was chasing fireflies in the yard, which she had decided were tiny stars that had fallen and needed to be set free. She was 7 now. She had her mother's laugh and her grandfather's stubbornness, which I considered a reasonable inheritance. "Dad," my daughter said, "do you think he'll ever understand what he did?" I thought about this honestly. Some people do, I said, when the story they've been telling about themselves runs out of room. But that's not your responsibility. And it's not mine. She turned her cup in her hands. I keep thinking about the first time. The first time he grabbed me. I told myself it was just once. That he was stressed. That if I handled things differently, it wouldn't happen again. That's what the pattern depends on, I said. It only continues if the person being hurt accepts responsibility for the person doing the hurting. You didn't cause this. You adapted to survive it. Those are not the same thing. She was quiet for a while. Then she said, "You were ready. Before it happened, you'd already put the cameras in. You'd already talked to a lawyer. How did you know?" "I watched the bruise on your wrist at Thanksgiving," I said. "And I listened to the spaces in your voice when we talked on the phone. After 40 years of following money through fraudulent accounts, you develop an instinct for what's being hidden and why. I hoped I was wrong. I prepared as though I wasn't." She nodded. She looked out at her daughter, catching light in the summer dark. "She's going to be okay," my daughter said. "I really think she is. More than okay," I said. My granddaughter cupped something in her hands and carried it carefully to the edge of the garden, then opened her palms and watched it rise. She turned back toward us, face bright. "Grandpa," she called. It flew to the lake. "They always do," I said. "That's where they're going." Driving home to Ottawa that evening, I had 4 hours to sit with my thoughts on the 401, the way I always had. I thought about the version of myself that had stood at Thanksgiving and seen the bruise and said nothing. That silence had cost more than I could calculate. Not in money, in time, in my daughter's safety. in the particular damage that is done to a child who learns, before she knows the word for it, that fear is a reasonable way to live. I don't believe in dwelling. It accomplishes nothing, and it costs sleep. But I believe in learning. I had the tools. I had 40 years of professional discipline, the knowledge of how to document and preserve and present evidence in a way that could not be dismissed. I had the resources. I had the standing, as the homeowner, to do what I did, and still I'd waited too long, because I hadn't wanted to believe that the man my daughter loved was the man he actually was. The lesson is not that I was too slow. The lesson is that the next time someone I love flinches, I won't talk myself out of what I already know. My son-in-law had looked at me 4 years ago across the table at a restaurant in Kingston and told me he would take care of her. He'd said it the way men say things when they want to be believed, rather than when they intend to follow through. I'd shaken his hand and told him I was glad to have him in the family. He'd called me a man who was too distant to notice what happened under his own roof. He'd made jokes, I learned later, to his friends, about the old accountant in Ottawa who was too busy with his spreadsheets to pay attention. He'd counted on my distance, on my age, on the particular way that people assume that experience and calm are the same thing as passivity. He'd miscalculated. Experience is not passivity. It is the opposite of passivity. It is knowing exactly what to do, and when, and how, and it is having built the tools you need before you discover you need them. The old accountant won, not by raising his voice or his fists, but by watching carefully, by documenting everything, by trusting the law to work when given the evidence it needed to work with, by being, in the end, exactly as methodical as a man who has spent 40 years following the money knows how to be. My son-in-law thought that was a weakness. He learned it was the only thing that mattered. If you found this story meaningful, please like this video, subscribe to Cold Vengeance, and share your thoughts in the comments. Click the video on the left to hear the next story. Thank you for being here.